How long does a trustee have to distribute trust assets? Under the California Probate Code, a trustee must administer the trust according to the terms of the trust instrument, including any asset distribution plan in that document. Because there are many types of trusts and innumerable trust agreements, the time frame is going to depend on the distribution scheme set forth in each individual document. For example, if a parent establishes a trust that's intended to provide ongoing support for a child through their lifetime, the instrument may call for ongoing periodic distributions rather than lump sum distributions at the decedent's passing. On the other hand, if a parent feels that their children are old and mature enough to handle a large lump sum distribution, then the assets most likely will be distributed fully after the creator passes away. Typically, if a trust calls for a one-time distribution of assets, it's going to take around 12 to 18 months for the trustee to distribute the assets to the beneficiaries, depending on various factors, including the complexity of the estate assets, creditor issues, etc. Because the particular requirements vary between trusts, trustees would be well advised to consult with an experienced trust lawyer to ensure they're complying with the terms of the trust. If you have any questions, schedule a free consultation on our website at rmolawyers.com. Can a trustee withhold money from a beneficiary? Yeah, sure. A trustee can withhold money from a beneficiary if the trust requires or allows them to do that, or if the circumstances of the trust administration justify it. In short, whether a trustee can withhold money from a beneficiary depends on the terms of the trust. For example, some trusts empower trustees to decide when to distribute assets and how much to give. Usually trustees with this kind of discretion can withhold money from a beneficiary if they reasonably conclude that a requested distribution simply isn't warranted. Other trust instruments restrict when trustees are permitted to distribute assets. For example, a trust may require a beneficiary to complete some level of education or reach a certain age before they're going to be distributed any assets. In these situations, the trustee must withhold the money from the beneficiary who requests it. Otherwise, that would be a violation of the terms of the trust. Sometimes specific circumstances of administration justify withholding distributions altogether. For example, in a taxable estate, the trustee will be obligated to have the assets appraised, discount analyses done, creditor claims gathered and vetted, etc., before an estate tax return can even be filed. And because an estate tax return is not due for 9 months from the date of death, and most estate tax returns go out on extension for an additional 6 months, most taxable estates aren't even in a position to begin making distributions for at least 18 months from date of death, although circumstances may require preliminary distributions during that time. In most cases, however, a trustee cannot withhold money from a beneficiary when a trust requires a distribution. What if a trustee refuses to distribute assets? If a trustee refuses to distribute assets, there are several legal avenues a beneficiary can take. In some situations, they may be able to file a lawsuit for breach of fiduciary duty against the trustee. They might also be able to request the probate court to order the trustee to make distributions or suspend or remove them from their trusteeship. If the trustee claims that the trust doesn't have sufficient assets to make required distributions, beneficiaries will want to request an accounting of the trust assets. If the trustee will not provide an accounting when requested, then the beneficiary can petition the probate court to order them to account. Then, if that accounting evidence is wrongdoing by the trustee, the beneficiaries can seek suspension, removal, and surcharge for any losses that show up in that accounting. Can a beneficiary dispute a trust? Yeah, a beneficiary can dispute a trust through a type of legal proceeding called a trust contest. Under the California Probate Code, a beneficiary of a trust can file a petition to void a trust if it was not created or funded according to the requirements under the law. For example, a beneficiary can dispute a trust for any number of reasons. 1, the required legal formalities were not observed when the trust was created or executed. 2, the creator of the trust lacked mental capacity to create or change the trust. 3, the trust was made or changed through fraudulent acts such as forgery. 4, the trust was made or modified because of undue influence, duress, or coercion. Understand, however, that a trust contest is going to delay distributions during the period that the trust contest case is pending. Similarly, most trustees aren't going to distribute any assets until the trust contest period expires, which If the trustee timely sends out the notice that's required under the probate code, specifically probate code section 16061.7, within 60 days of death or any other cause of irrevocability, then the contest period can be abbreviated or shortened to 120 days from the date of service of that notice, and a copy of the trust is provided. These timing issues are really complicated and fraught with traps that should not be examined without counsel. When should I contact a trust litigation attorney? If you're the beneficiary of a trust and the trustee refuses to distribute trust assets, or if you're a trustee trying to make a determination whether assets should be distributed, you should contact a trust litigation attorney immediately. Although trustees can sometimes withhold money from beneficiaries, the legal requirements a trustee must follow are going to depend on a trust language, and an experienced trust litigation lawyer can review the trust documents and advise you as to what the obligations are. If a trustee is wrongfully withholding trust distributions, then that trust litigation attorney is going to be able to help you pursue a legal action to secure what you're entitled to. Have questions? Visit our website, schedule a free consultation. At RMO, we protect you and your family's legacy. Thanks for watching.